Welcome to Literary and Jury Charge Practice. Let's get started with this jury charge. Ready? Here we go. Ladies and gentlemen of the jury, in giving you the law in this case, the court wishes to make it clear at the outset that the court will not discuss the facts because that is your main function. The court will simply give you the principles of law which apply to criminal cases in general and then discuss with you the elements of the crime which is charged in this indictment. The function of the court is to conduct the trial in an orderly manner, to rule upon questions of law arising in the course of the trial, and to instruct you as to the law which applies to the case. It is your duty to accept the law as the court states it to you, and you should consider all the instructions as a whole. The function of the jury is to determine the facts. You are the sole and exclusive judges of the facts. You should determine the facts solely from the fair consideration of the evidence. What the verdict shall be is your duty and responsibility. It is your own recollection of the evidence that will control during your deliberations in the jury room. The statements of counsel are not evidence. They are only intended to assist you in understanding the evidence and the contentions of counsel. The indictment itself, which you may take to the jury room with you if you desire, is not evidence. It is merely the formal manner of accusing a person of a crime in order to bring him to trial. You must not consider the indictment as any evidence of the guilt of a defendant or draw any inference of guilt because he was indicted. In this case, ladies and gentlemen, as you are well aware, there are two defendants. In giving you these instructions, I will refer mainly to the defendant because what I say applies to each defendant. In all criminal cases, there are certain important rules that you must bear in mind. Among those is what we call the presumption of innocence, the burden of proof, and reasonable doubt. In every criminal case, the law presumes a defendant to be innocent of the crime charged. The law permits nothing but legal evidence presented before the jury to be considered in support of any charge against the defendant. The presumption of innocence alone is sufficient to acquit a defendant unless you are satisfied beyond a reasonable doubt of the defendant's guilt based on all the evidence introduced in the case. A reasonable doubt may rise not only from the evidence introduced but also from a lack of evidence, since the burden is always upon the government to prove the defendant guilty beyond a reasonable doubt of every important element of the crime charged. There are two types of evidence from which you may determine the truth as to the facts in any given case. One is direct evidence and the other is circumstantial evidence. Direct evidence is the testimony of one who states he has actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is the proof of a chain of facts and circumstances indicating the guilt or innocence of a defendant. The law makes no distinction between the weight to be given to either type of evidence. You should weigh all the evidence in the case. After weighing all the evidence, if you are not convinced of the guilt of the defendant beyond a reasonable doubt, you must find him not guilty. You as jurors are the sole judges of the credibility of the witnesses. In other words, you alone are to determine whether to believe any witness. If there is any conflict in the testimony, it is your function to resolve the conflict and to determine just where the truth is. You should give the testimony of each witness such weight as in your judgment it is fairly entitled to receive. Now, ladies and gentlemen, the weight of the evidence is not necessarily determined by the number of witnesses testifying on either side. You should consider all of the facts and circumstances in evidence to determine which witnesses are worthy of belief. Both of the defendants have taken the stand as witnesses in their own behalf. With reference to such testimony, the court instructs you that the defendants have a right to become witnesses in their own behalf. Their testimony should not be disbelieved just because these witnesses are the defendants. In weighing their testimony, however, you may consider the fact that the defendants have a vital interest in the outcome of the trial. You should give their testimony such weight as, in your judgment, it is entitled to receive. Ladies and gentlemen, as the court earlier indicated to you, there are two defendants on trial. Each defendant is entitled to have his guilt or innocence as to the crime charge determined from his own conduct and from the evidence which applies to him as if he were being tried alone. You may find any one or more of the defendants guilty or not guilty at any time during your deliberations. You may return your verdict of guilty or not guilty with respect to any defendant. In the crime of robbery, with which these defendants are jointly charged in the indictment, the state must prove beyond a reasonable doubt that the defendant took property of some value from the owner against the will of the owner, and having carried it away, took such property without the right to do so, and with the specific intent to steal it. It is necessary that the property taken away have some value at the time of taking. The size of its worth is immaterial. The offense is not committed where the property is taken with the full knowledge and consent of the owner, or one authorized to consent in its behalf. You should consider the case of each defendant on its own. All right, now let's try a little literary practice. And this is called Olympic thinking. Olympic thinking. All right, ready? Here we go. After the amazing show of the Summer Olympics, it would be hard to not think about it. Were you as inspired as I was by the effort and the performances by so many people from so many countries from all over the world? Here are some questions to consider as you reflect on the inspiration from watching Olympic athletes. If being a court reporter were an Olympic event, would you make the team? If you made the team, would you win a medal? Can you imagine what it would be like to feel the weight of the gold medal on the center of your chest while your flag is being raised to the sound of your national anthem? You can have similar feelings in your personal and professional life if you adopt what I call Olympic thinking. One reason we admire Olympians is because of their high standards. These high standards are the reason Olympians perform as they do. Raise your own standards, apply some Olympic thinking, and improve your performance as a result. Olympic thinkers take risks. At the 1988 Olympic Games in Seoul, Korea, millions of television viewers around the world watched as American gold medalist Greg Louganis hit his head on the board during the 9th dive of the springboard preliminaries. Only 12 divers would qualify for the finals. Greg's accident dropped him from 1st to 5th place. With 4 stitches in his head and a waterproof patch, Greg returned for his next dive and executed possibly the best dive of the competition. Everyone watching witnessed this moment of extraordinary courage. In his book, Breaking the Silence, Greg said, "You don't win gold medals by playing it safe." In our business and personal lives, we can't play it safe and expect to achieve our highest levels of success. Fortunately, the risks are seldom as bad as we imagine, and the rewards are often greater than we expected. If the primary motivation behind your decision is to avoid unlikely worst-case scenario, your options will be severely restricted. Olympic thinkers take risks and don't permit the remote possibility of a negative outcome to overshadow the probable positive results. And we'll get back to that one. Now let's try some more jury charge practice. This is the subject of this jury charge is called common carrier. Ready? Here we go. Gentlemen of the jury, a common carrier is one who undertakes for hire to transport from place to place the goods or persons of those who choose to employ him. The defendant in taking and transporting the machine here in question was a common carrier for hire. Generally, a common carrier of goods ensures the safe transportation of the goods committed to him for that purpose, and he is responsible for all damages to the same while in transit. There are, however, certain exceptions to this rule. One of these exceptions is if the loss or damage arose solely from the fault of the shipper himself, that is, if the goods or freight transported is improperly packed or improperly loaded by the shipper, and this fact is not apparent or known to the carrier, and the carrier is not at fault himself in causing the damage, then the carrier is not liable for the loss or damage resulting from such improper loading by the shipper. It cannot be said, however, that the carrier must have known that the machine was not in fact safely loaded. The shipper usually knows better than the carrier the manner in which the goods have been packed or loaded and the manner in which they should be packed or loaded, and even though the carrier may have knowledge of some defect in the packing or loading, still, if it is not apparent to the ordinary observation of the carrier that the goods cannot be safely carried in the condition in which they are presented, the carrier should not be held to take the chances of damage or injury from such improper packing or loading. The burden of proof rests upon the defendant to prove by the preponderance of the evidence that the loss or damage arose solely from the improper loading by the defendant. Now we'll get back to our Olympic thinking. Ready? Here we go. Olympic thinkers don't make excuses. Having a good excuse for a poor performance does not compare with the feelings of accomplishment that come when producing results. Olympic thinkers focus on results. Having a good excuse for missing your children's special events is not as good as being there. Having a good reason for not meeting your goals is not the same as achieving them. Having a good excuse for not taking care of your physical health is not the same as being physically fit. Failing with an excuse is simply not as good as succeeding. Only the best practice when they don't feel like it or when it is inconvenient, says Olympic gold medalist Peter Vidmar. To make the Olympic team, I had to be an even higher achiever. I made a clear list of objectives that I had to accomplish every day in the gym. If my workout lasted 3 hours, great. If the workout lasted 6 hours, tough luck. I wouldn't leave without accomplishing my objectives. My daily goal was to achieve knowing that I had done everything I could. Olympic thinkers focus on results and figure out a way to stay on track with their work program, training program, or their health program. Olympic thinkers tend to be perfectionists. It's an interesting paradox that the same people who criticize their friends or colleagues for being perfectionists can be moved to tears watching an Olympic score a perfect 10 or set a new world record. It's difficult not to appreciate perfection. Olympic thinkers tend to seek perfection. When you compete with the best, what else can you do? If perfection is not your goal, it is difficult to achieve high levels of success. Would you rather have a goal of a perfect 10 and fall short with 9.9, or set your goal at 8 and achieve it? The Olympic thinker prefers the better result. I have a friend whose motto is strive for perfection, settle for excellence. Beware of using perfectionism as an excuse to fail or not produce results. Remember, Olympic thinkers produce results, not excuses. Seeking perfection doesn't mean you never get things done. It means you get things done well. Nadia Comaneci was the first Olympic gymnast to score a perfect 10. During an interview, Comaneci explained, I always underestimated what I did by saying I can do better. To be an Olympic champion, you have to be a little abnormal and work harder than everyone else. Olympic thinkers seek perfection as their ultimate goal. All right, back to some jury charge practice. The subject of this jury charge is sales warranty. Ready? Here we go. Ladies and gentlemen of the jury, the burden of the proof rests upon the defendant to prove by the greater weight of the evidence that the property in question was in a damaged condition as claimed by him when the property was delivered to him, at which time the title passed from the plaintiff to the defendant. Any damage, of course, after such delivery, which was not due to any negligence or fault on the part of the plaintiff, could not be charged to the plaintiff. Upon a breach of warranty on the sale of personal property, the buyer has the right to recover for all damages which in the contemplation of the parties or according to the natural or usual course of things may result from said such breach. The ordinary measure of damages is the difference between the actual value of the goods sold and what would have been their value if they had been as warranted. In this case, the defendant claims to have sustained such damages because of certain losses sustained by reason of plaintiff's breach of warranty, and in this claim is included profits or gains which he would have realized from the chickens purchased had they been in the condition as represented. He claims that because of his losses and the death of these chickens, such profits were denied him. It is a law that where reasonable profits or gains are prevented and losses sustained because of a breach of warranty, and where the losses may be determined with reasonable certainty from the evidence, then such contemplated profits may be recovered by the buyer. However, such damages can be recovered only when capable of being ascertained with a reasonable degree of certainty, and which such contemplated profits are within the contemplation of the parties as a result of the breach of warranty. Right, we'll get back to some literary material. Back to our Olympic thinking. Ready? Here we go. Olympic thinkers have high standards. Olympic thinkers recognize that the problem with high standards is that most people choose not to have them. So when you choose high standards, you choose to be in the minority. Olympic thinkers would rather be in the high standards minority than the mediocre majority. Those who choose mediocre standards have a large support group. Those who choose high standards discover a real support group. Mediocre people support each other by buying each other's excuses and letting one another off the hook. The people with high standards truly support one another with encouragement to take their endeavors to the highest level possible. For example, the mediocre leader, coach, or manager will tell us to set attainable goals, which usually means setting goals too low. Leaders with high standards urge you to set high goals that might seem unattainable and then help you stretch to attain them. Which do you think is more satisfying? Perhaps people set their goals low to avoid failure, yet you are much more likely to fail because your standards are too low than because they are too high. In fact, can you think of people or companies who failed because their standards were too high? Neither can I. But it's easy to think of people and companies who failed because their standards were too low. People with high standards always set the new standard. Having just won 2 gold medals in Lillehammer, Norway at the 1994 Winter Olympics, Bonnie Blair did not go home to gather endorsements, contracts, or be the guest of honor in the parades. Instead, she made it a classic high standards Olympic thinker trip to Calgary. Her collection of 5 Olympic gold medals would have been enough for most, but Bonnie Blair was in the best speed skating condition of her life, and she had one more challenge to meet. No female speed skater had ever gone faster than 39 seconds in the 500 meters, so Blair went to the Olympic Oval finale invitational event in Calgary to see if she could break this barrier. When she crossed the finish line in 38.99 seconds, she became the first woman to skate this fast. Blair's world record was to women's speed skating what Roger Bannister's first sub-4-minute mile in 1954 was to running. 1 year later at the World Cup in Calgary, Blair beat her own world record for the 500 meters in 38.69 seconds. Why is Bonnie Blair one of the greatest Olympians in history? She epitomizes the high standard Olympian. She is an example for all of us who aspire to be Olympic thinkers. You can't choose mediocrity if you choose to be an Olympic thinker. All right, and that will conclude our literary and jury charge practice.